Hello, everyone. How's it going? This is immigration attorney Moumita. I'm coming to you live to talk to you about immigration. And tonight I have a special treat for all of you. I know that many of you have called our firm. Many of you might already be working with us. And sometimes when you're working virtually and you're talking to us on the phone, one of the biggest questions that you may have is, who am I talking to if I'm not talking to the attorney? Well, you know that my mission is to help as many people that I can. And it's not possible for me to speak to everyone. So I have an amazing team of intake specialists who help us talk to clients to find out what their problems are, to find out what the issues are, and to make sure that our clients get the help that they need if we can help them at all. And today I have a special guest for you. I have over here with us Diego Fu, who is one of our amazing intake specialists, because I wanted you to have a little bit of an idea of who you're talking to. It's really important for me, for everyone out there to know that it's not just me who cares about our clients. It's not just me who cares about what happens to our cases, but the entire team from the top to the bottom, from the start to finish. We all care about what happens to our clients' cases. And when you start working with us, one of the first people that you may talk to is actually an intake specialist. So today I wanted to introduce to you Diego Fu, who is one of Rahman Law Firm's amazing intake specialists, to talk about his experiences. Hi, Diego. How are you doing tonight?
Very good, Moumita. Thank you very much. And thank you, everybody, for joining the live. And I just wanted to give you thanks just because if you guys do call us, I will be actually the one speaking to you. I will be hearing about your case. I will be asking a few questions. And I'm just going to be able to um, find out what is the best strategy for your case and how we're going to be able to help out. So thank you, Moumita, as well, for giving me this opportunity.
Thank you, Diego. It's such a pleasure. So, Diego, tell us a little bit more about what you do here at the firm.
Okay, so one of the first things that I actually do is, as you mentioned, once you guys, the people who need help, the immigrants, everybody who's calling us, once you guys give us a call into the firm and you guys are scheduling the appointment, you will be able to speak with me. I will ask you a few questions about your immigration background, a few questions about your case, and based off that, we're going to be looking for what is the best strategy for your case and finding out how we can help with everything that you need.
Amazing. And, it's no secret to everybody. And hello, Cletus. How are you? Hello to everyone who's watching. And we're definitely going to answer some questions together in a little bit. But tell us, Diego, I bet that you might hear a lot of some common questions or some common concerns that clients have, because it's no secret that one of the biggest cases that we work with is VAWA, which is for persons who are married to U.S. citizens or to green card holders, or even parents of U.S. citizens who are suffering in that relationship in so many different ways. And this is a really amazing avenue for people to get a work permit or a green card and just get protection that they need. And we also work with a lot of T visas as well for persons who've been in jobs where the boss has really abused them in different ways. So tell us, Diego, has there been any sort of common question that you get from clients that you wanted to talk about over here?
So one of the most common questions I actually see is the people are not sure about. They always ask me, "Is my case strong enough? Is my experience good enough to be able to qualify for VAWA?" And based on everything we see, everything we discuss with the attorney, the most important part about VAWA is yourself, your experience, and everything that it has, how it has affected you. It's not always about other evidence or do you have a picture, do you have a video. No, the most important thing about VAWA is you and your experience. So that is one of the most questions, one of the most common questions I get asked. So I think that if you do have a VAWA case, you have something similar, it would be great for you to review this case so you can understand what is it that VAWA is and how it can help you.
I think that's a really good point, Diego, because people are definitely worried about whether they're going to get approved. And I think a big fear that people have is that their case is not believable. I spoke with a client earlier today. We're in the process, we're about to finalize and file her case. and her case is really strong. It's one of the more stronger cases that that we have, and a big fear that people have is that what they've gone through, like you said, is not good enough. It's not good enough. It's not strong enough, and it's not believable enough. And I was trying to count up how many cases that we've filed, and we've filed a lot of VAWA cases, and every single case can be made strong just through the words of our clients. That's why we take so much time to make sure that we interview properly and that we get down the experiences, because that is evidence. And something that I want to remind everyone, that when you're filing for VAWA, the standard of evidence is any credible evidence, which literally means you or any affidavits, anything like that. So that's really important for people to hear, is that if you've been worried about doing your case because you think that what you went through is not enough, I want to ask you, well, is what you went through something that's been affecting you? If something has been affecting you, if you stay up at night, you can't rest, you can't sleep, you're not the same person that you used to be, you have trouble enjoying the daily activities, or you're thinking about these bad things all the time that have happened to you, that's usually a sign that what you have gone through is good enough for VAWA. So thanks for bringing that up, Diego. Tell me about another fear that you hear about a lot from clients that you think is important to talk about.
So I would think it's important to talk about is one of the things I got asked, for example, today was, what would happen if I get divorced? This is a question that we see a lot, but for VAWA, there's still time frame after you get divorced to still apply for it. And another thing is, what happens if my case has already been filed with my spouse, but she no longer wants to help. She does not want to go to the interview, or she actually missed the interview. And with VAWA, there is a lot of things that we can do, even if this person is just not willing to help. So there are a lot of things and a lot of insecurities that we might be able to just address immediately. So you can be um, just have a peace of mind for this type of case.
Okay, amazing. Let's talk about those two things, because a lot of people, can you still file for VAWA if you've gotten divorced, right? And the answer is really that it depends, because everything depends on what that date of divorce is. And I want to bring up one more thing too, which many people may not know about, is, I want you to be careful if you're in, we see every once in a while that a client may come to us with an annulment of their marriage. Now, you may want to get your marriage annulled because you have gone through hell and you just want to erase all of it, and you think that annulment is the way. But I want you to know that if you get your marriage annulled, then you will also be ineligible for VAWA. So, because basically, if you get it annulled before you file for a VAWA, it basically means that the marriage does not exist at all. So I want you to be careful. And if your spouse, if you are an immigrant and your spouse tries to get your marriage annulled, I want you to fight that. Hire a lawyer, get a family lawyer, somebody who specializes in divorce and matrimonial law, to fight that annulment. Because a marriage should only be annulled if it was completely fake, right? If it was fake, then you get annulled. But that what you're going through is usually real, and that your relationship is real. So if your spouse tries it as an abusive tactic to get you to annul your marriage, fight it. But if you've already gotten divorced, it may still be okay to file for VAWA as long as 2 years have not passed. So be really, really vigilant about your deadline if you got divorced, and make sure you call us because the clock is ticking if you've already gotten divorced. And the second thing I think that you talked about, Diego, was about, actually, I can't remember anymore. What was the other thing?
So it was about the divorce and what would happen if my spouse has already filed for me and she no longer wants to go into the interview, or she does not wants to help anymore.
Yeah, that's a good point too, because sometimes when you've already started the green card process with your spouse, you may think that that's it. You can't do anything, you're stuck with it. You have to finish that out. And the truth is that that's just not true. Just because you started the process with your spouse does not mean that you are legally bound to that process for the rest of your life. That's actually why the government has VAWA, to enable you to to be free of that and to file your own case and have that control back in your own life. So even if you have already filed a case with your spouse or they filed for you, it does not mean that you are not able to file for a VAWA. In fact, you can have the two processes at the same time, and immigration would just need to give priority to the VAWA. So don't lose hope. Basically, don't lose hope. Just because some certain things are not going right. I especially really. I really feel a lot of pain to also hear about clients who keep sticking through a lot of the things that they're going through just because they think that there's no other option but to stay together with the spouse and suffer through what they're going through. And I want you to know that you don't always have to do that. You don't have to do that. You may have an option. So the best thing really is to give us a call, and so we can find out, like with someone like Diego, who's going to ask you the questions and find out what your options are. Diego, before we let you go, tell us about some good things. Tell us about why you do what you do.
So the first thing that actually got me interested in the firm was the type of cases that we see, um, which is why I was just eager to start helping. First of all, we see a lot of cases based on immigration, obviously, right? Uh, but once I figured out and once I understood what VAWA was, I figured that there was a lot of people, a lot of immigrants in the United States that are not getting the help they deserve. And I have a lot of a family that are immigrants and are in the United States and have been going through um, immigration issues or difficult tasks or just obstacles. And what VAWA did for me, or what it clicked for me, is that there are people who need help just because they're married to a U.S. citizen, but they're not providing this help. It just made me think that I would be able to help those people as well, and that is one of the main things that I like what I do. A lot of things as well is once you tell someone we're going to be able to help, or once someone finds out that there's actually a type of case that can actually protect them, it's just great to hear. For example, today I got a call from someone who actually saw live, and he was just very happy because he had the courage to call after he saw the live, after he saw our videos, and he was just very um, excited about this new possibility that there is for him. He just did not knew about before, and it's just great to hear how people um, just they become very happy. They get happy as soon as they know there is something that we can do for them. So I think that is one of the main things. It's just helping out everyone who needs that help.
Amazing. Thank you so much. Diego, thank you so much. I'm going to go ahead and start answering some questions from our viewers live. Thank you. Wishing you a really great evening, and I'll see you again. Let's see what questions we have. All right, guys. First of all, I want to say hi to Cletus. How are you doing? I have a question from Dico Noor. Dico Noor is asking, is a writ of mandamus worth it after waiting for 3 years for my visa under admin processing? Dico, that's such a good question. So let's talk a little bit about what admin processing is. Admin processing is when you're filing for a visa overseas, you've had your interview at the post, but you don't get approved. And sometimes they'll even say that your visa is denied and you are in administrative processing. First of all, what is administrative processing? Administrative processing is usually just a blanket term that a consular post may put on your case that says that, number one, they're either doing additional investigation, or number two, they are looking to see if there's any fraud, or number three, they need additional documents from you because they are missing or they're expired and they need it to make a decision in your case. So admin processing is basically just a general term and phrase that basically means that the consulate does not have the ability to make a decision on your visa application at the moment. And if your case has been in admin processing for 3 years, you are probably beside yourself with feeling crazy about why you're not getting a decision and what is taking so long. So can a writ of mandamus help you in your case? And the answer is yes, it may actually help you in your case, because when something is pending for more than 2 years with immigration, it means that the case is ripe. It's ripe for processing, and immigration, USCIS, or the Department of State, whoever it is, needs to make a decision on their case. Now, a writ of mandamus is basically a federal lawsuit asking, basically saying that the government needs to make a decision on a case. So keep in mind, Deco, that a decision can either be an approval or a denial. So if you do a writ of mandamus, sometimes it can mean an approval, or sometimes it can mean that your case gets denied, because that is still a decision in the case, okay? So good luck. Mr. Mohit's asking, how long does it take to get a work permit after fingerprints in a VAWA case? Mohit, so I would say that when you're filing a VAWA case this year, I would say an average timeline for work permits is usually about 6 to 8 months. And after you get your fingerprints done, I would say you should average it out to be about 4 months after that you might get your work permit. But keep in mind that these processing times go up and down. So whatever I'm saying now can still change in the future. It could end up taking longer, or it could end up taking less time. So good luck, Mohit. Yvette, thank you for listening from the Virgin Islands. How long does it take to process an I-130? Is there any update? So Bilal, an I-130 these days is still taking kind of the same amount of time that it was last year. It's still taking anywhere from 8 months to a year and a half in the majority of cases that we're seeing. But we do see that if you are filing an I-130 along with an I-485 and you're doing a one-step marriage case or adjustment of status case inside the United States, we do see here in the office that those processing times are shortening up and they're tightening up across the United States, because the government is trying to work through its backlog and eliminate that backlog as much as they can. So if you filed an adjustment of status, I would say that you might end up getting a decision sooner than before. Do you have an office in Minnesota, Deco? We do not have an office in Minnesota. We only have an office in New York, but we work with clients all over the United States. I know that you asked a question about doing a writ of mandamus. That's not something that we're helping with, but you can still give us a call and we'll talk to you some more. I once to get my girlfriend from the Philippines to the US. I can't fly there. Can we get married apart and then bring her over here? So Michael, that's a good question. You know, a lot of times if you have a loved one who's outside the United States and you're not yet married and you want to bring them over here, obviously, because you want to have a married life here together, what are some good options if you can't, they can't fly to this country and you can't fly to their country? Well, one, you can do a fiancé visa. A fiancé visa is a great option for people who can't really meet each other right now, but there is a requirement that you must have met each other physically in the same space at least once in the past 2 years. So Michael, if that did not happen, if you have not seen your girlfriend, if you have not visited each other in the last 2 years, then the fiancé visa may not work. So another option that you could have is to fly to a different country. You know, if you can't fly to the Philippines, maybe you can fly somewhere else and just meet halfway around the world, get married in that country. Obviously, check the laws to make sure that your marriage is going to be considered legal in that country, and then you can file for a spousal visa instead. I got a medical courtesy letter for an RFE. What does that mean? From Rohander. So if you have filed for adjustment of status, then a lot of people are now getting letters for their medical exam. There are two types of letters. One is a courtesy letter, and the second is an actual request for evidence. Now, if you get a request for evidence, it will have a deadline on it, and it will have very specific instructions on how you can deliver your medical exam to USCIS. If your letter does not have a deadline on it, it is not a request for evidence. But here is what I'm seeing. Even today, I got an email from the New York Field office that was titled "Courtesy Letter for a medical exam," but even though there was no deadline in it, there was instructions in this email that said that you can drop off your medical exam in our field office by hand. So what does that mean if you get an email like that? Well, number one, it's not a deadline, but number two, if they're telling you to go ahead and drop it off, I would take this opportunity to get your medical exam done and follow the instructions on the letter to drop it off. But what if your letter does not have any instructions? What if it is simply a letter that says, your medical exam is missing, please wait for an interview notice or an RFE before taking further action. That's what you should exactly do. Don't do anything until you get an actual interview letter or you get an actual RFE, okay? I hope that helps, Rohinder. Is there any such thing as too many years have passed before applying for VAWA from Yvette? Yvette, what a great question. Is it ever too late for filing for VAWA? And the answer is only if you have gotten divorced. If you have gotten divorced, then if more than 2 years have passed since the date of divorce, then it's too late. But for me, if you're married, if your relationship, you were together 20 years ago and you suffered during that time, it's not too late for me to file VAWA for you, and it's not too late for it to be a successful VAWA as long as you are still legally married to that spouse. So that's really the only limitation that you have in terms of time when it comes to filing for VAWA. The only time limitation that you have for VAWA is a date of divorce, because once the divorce is final, then you only have 2 years to file for VAWA. Other than that, it doesn't matter how long ago you lived together. It doesn't matter how long ago you were together as a couple. It doesn't matter how long ago the abuse happened. The abuse happened and you were married, then that's all that we need, okay? And we also have to show some other things like shared residency and stuff like that. So if, theoretically, if it happened a long time ago, then it might be harder to remember the events. It might be harder to, if you needed some witnesses to get things like that, but still it's worth a try. So Yvette, if you did suffer, even if it was a long time ago and you're no longer in the US, if you ever suffered inside the United States at any time, then this could be an option for you. My wife has a removal order and a 10-year asylum denied. I'm a US citizen. I filed an I-130. It's approved a week ago. Can we file a joint motion? How long will it take, and is that the best way to go? From Ramji. Ramji, great question. So if you have a deportation order and you're also married to a US citizen, can you actually go forward in your case? And the answer is yes, you can. If your I-130 has been approved, also depends on why you got ordered removed. If you got ordered removed, if you have a deportation order because your asylum was denied and not for any other issue, then usually what we can do is we can, once the I-130 is approved, then the government can be asked through a motion to reopen your case and possibly recalendar it or get it dismissed. And we have had great success in doing this. An approved I-130 is a great thing to have. There's some other factors that we need to look at too, but you can give us a call, Ramji, at 212-248-7907. Gaurav, nice to see you. Hi, Ryan. Jenna Lee is asking, I've received my second prima facie notice. Is that a good thing or just a regular procedure for a VAWA case? Thank you so much. So Jenna, it's regular. Let's look at it this way. When they give you a prima facie determination, it's a good thing. And the thing is that the prima facie will expire usually after a year or 180 days. I can't remember off the top of my head. However, keep in mind that because the VAWA case itself is going to take the government about 2 years to 3 years to approve, they have to keep on sending out the prima facie, and it'll keep getting renewed until your VAWA is approved. So generally, it's just a normal thing. It's part of the process, and it's not a bad thing at all. In fact, it's meant to help you. My I-485 has been processing for 20 months, and I have still not gotten a decision from the Charlotte Field office. Should I file an expedite or file a lawsuit? So let's talk about this. What is an expedite? An expedite is when you're making a request to expedite or to speed up processing of a case because of an emergency that you're having. So Lawrence, if you want to expedite your case, you have to show what the emergency is, and USCIS will decide it on a case-by-case basis according to their criteria for expedite, which can be a little bit harsh. So you actually have to show an emergency, like a true emergency of a humanitarian or financial reason. Those are usually the types that we do in our office. Or can you file a lawsuit? So we talked about a writ of mandamus earlier on this live, and a writ of mandamus is a lawsuit against the United States government, asking them to make a decision on a case because it's been taking too long. Now, if you have been waiting 20 months from the time that you had your interview and there's still no decision, it's a pretty dang long time. However, it may be a little bit too early because usually USCIS believes, or the government, usually most government attorneys take the position that 24 months is too long. 20 months is still just fine, but 24 months, once it gets into the 24-month period of time, that's when it becomes too long to make a decision. And that's when mandamuses are usually a little bit more successful. So I would say start the process for looking for an attorney right now to help you with that writ of mandamus. But your attorney, whoever you work with, is probably going to want to wait until you reach that 2-year mark, that 24-month mark, to file that writ of mandamus because it'll be a little bit more powerful at that time, okay? So Ashwani Grover is saying, my case is now showing that it's actively being reviewed. How much more time will it take? So how much time it'll take, usually if it's being actively reviewed, I would say like within the next 6 months, you should receive some sort of notification from USCIS, Ashwani. Shabazz Ahmed is saying, make it a video call. We're definitely working on that, Shabazz, so give us some time. Is NBC part of I-130 faster than the I-130 approval from Ryan? Yes, definitely. So if you're filing for a visa overseas, it's a 3-step process. The first part is the USCIS processing of your I-130. The second is NBC processing, and the third is usually the interview itself. And I would say the NBC processing, especially if you have an electronic case, it's gonna take a quicker time than the I-130. I would say on average, NBC processing can take between 2 months to 6 months, depending on what's happening in your case. What if you get an RFE for a medical and they say to submit it to field's office address? What does that mean? So Nikita, literally it's the same thing. And I have a lot of questions about the medical exam. If you get an RFE for the medical exam, you should, if you don't respond to it, then your case would get denied because it's giving you a deadline. And the USCIS is pretty stringent about that. If they give you an RFE with a deadline, if you don't respond to that RFE by that deadline, then they would deny the case. However, what happens though if you filed, you started out your case together with your spouse. You started out your case together with your spouse, you're no longer together, and you get your medical RFE right now, but you need to file for VAWA, or you are in that VAWA process. Well, I'm taking the position that you still have to respond to that RFE, but if you're no longer living with your spouse, I believe it's safer to notify the field's office that you're no longer living with your spouse and that you're requesting time to file a VAWA application. I think you have to be very, very careful during this time, because if you get approved a green card and immigration has the impression that you're still living with your spouse when you're not living with your spouse, then it can put you in jeopardy in the future. And you may be accused of having committed a misrepresentation. Okay, Chala Lime, you can give us a call at 212-248-7907. Enrique is asking, do you have an office in California? We don't, but we still work with lots of clients in California because we work with clients all over the United States. Last question, I'm going to answer from Maria Alexander saying, my fiance has a green card. If we get married, how long would it take for me to move to the USA? Maria, if you're the spouse of a green card holder, your case is, and you're not inside the United States right now, it's going to take about 2 to 3 years on average for you to be able to come to the US. How about my child aged out due to the delay caused by the pandemic? Could I still migrate with him? He's turning 22. We've been documentarily qualified since last January. Is he still covered under CESPA? So Josephine, that's a really complicated question. CESPA is a very complicated formula. I don't have the ability to do that formulation for you right now. But, so many factors depend on whether your child is still protected. Number one is how long that application was pending before they turned 21. That's usually the deciding factor, okay? All right, everyone. I hope everyone enjoyed this. Thank you so much for joining. I hope you enjoyed the special little interview with Diego. If you want to see more of that, let me know, and I'll get more of my intake specialists here because they're amazing, and we all care about your case, okay? Have a great night, and call us at 212-248-7907 if you are wanting to get an appointment. Take care.